Right now, many families in Connecticut don't have a way to secure their parent-child relationships, leaving their children vulnerable. Current Connecticut law doesn't equally protect children of unmarried same-sex couples, children born through assisted reproduction, or children of de facto parents.
My name is Ashley Taylor, and I am testifying in support of Raise Bill number 6321.
My name is Stephanie Ocasio-Gonzalez, and I am testifying in support of Raise Bill number 6321.
I am testifying on behalf of myself and my fiance, Adriana. Adriana and I are currently expecting a child due in mere weeks. We are extremely nervous about Adriana's legal parentaging status. Despite being my partner and co-parent in every sense of the world, Adriana will have no legal connection to our child at birth because she's not a biological parent. We are currently pregnant, and I am in my third trimester.
I'm testifying on behalf of myself and my family, my wife Denise, our son Javen, and our daughter Destiny. COVID heightened an already existing fear for me, which is what would happen to our children if something were to happen to me. Having preconditions as well as working in the medical field, that question loomed over me. Our 14-year-old son Javen is from a previous relationship, and Denise came into our lives when he was just 3 years old. We make decisions together about his life, and we jointly provide for him. Denise is Javen's mother, and Javen feels the same. Yet because we live in Connecticut, she has no legal connection to our son. The only option to secure Javen's relationship with Denise is an adoption, which will be a difficult litigation that will require us to terminate the rights of Javen's birth father.
Since we live in a state that we think of as supportive of LGBT people, we just assume that we will both be recognized as parents under the Connecticut law. Throughout the fertility process, we have been treated by doctors and nurses as a couple who are both parents. We jointly signed contracts and forms at the clinic in which we both committed to the responsibility over any child we have. But under the law, we are not treated as parents of our children. Adriana will have no legal connection to our child, and in order for her to be legally recognized as our child's parent, we would have to wait until our child is born and file adoption papers, which can cost $2,000 to $3,000. There will be a period of time when Adriana is not a legal parent to our child, which makes me scared, and that gives me a lot of fear, especially because of COVID-19.
I gave birth to our 2-year-old daughter, Destiny. Both of our names are on her birth certificate, but without a formal judgment, some states may not recognize Denise as the lawful parent of our daughter. I live in fear that if something happens to me, Javen, as well as my daughter, will lose both of their mothers. The CPA will solve this problem. We would be able to complete an acknowledgement of parentage, and Denise would be recognized as Destiny's parent in Connecticut and across the country.
The Connecticut Parenting Act would protect our family and guarantee that our child has the security of 2 legal parents from the moment of birth. The bill will allow us to sign a simple voluntary acknowledgement of parentage to guarantee that Adriana will be our baby's mother always and forever. We will be legally recognized as a family since day one.
Get involved in the fight for parentage equality. Sign up for updates about the CPA at glad.org/CPA. If your family has been harmed by these outdated laws, share your story.